The divorce mediation was supposed to be straightforward. Rachel's attorney presented her financial disclosure showing assets totaling $30,000, our house, her retirement account, and some modest investments. As a certified financial forensics investigator with 20 years of experience tracking hidden assets, I immediately recognized the signs of incomplete disclosure. What Rachel didn't know was that lying about assets to someone who specializes in finding hidden money was about to become the most expensive mistake of her life. My name is Richard Kim, 46 years old, and I run a financial investigation firm that helps attorneys, insurance companies, and individuals locate concealed assets. My specialty is tracking offshore accounts and complex financial structures designed to hide wealth. Rachel and I had been married for 8 years, and she knew what I did for a living. But apparently she thought her deception would be sophisticated enough to fool me. I sat across from Rachel and her attorney, reviewing documents that showed a woman with modest means, seeking a fair division of our marital assets. But the numbers didn't match what I knew about our actual financial situation. Richard, Rachel's attorney said, my client is proposing a 50-50 split of all marital assets. Based on our disclosure, that would mean approximately $170,000 to each party. I nodded politely while mentally calculating the massive discrepancies I was already identifying. According to Rachel's financial statement, she had $23,000 in her checking account, $67,000 in her 401k, and owned a small investment portfolio worth. She listed her income as $48,000 annually from her job as a marketing coordinator at a tech startup. The problem was that I knew Rachel had inherited $1.8 million from her grandmother 6 months earlier. What Rachel had apparently forgotten was that I'd helped her understand the inheritance tax implications when the money arrived, and I had copies of all the original documentation. Rachel, I said carefully, I notice your financial disclosure doesn't include the inheritance from your grandmother. Her face flushed slightly. That money was used to pay off debts and expenses. It's mostly gone. What kind of debts and expenses? Student loans, credit cards, some investments that didn't work out. I pulled out my own folder. According to the inheritance documentation I helped you with, you received $1.83 million in cash and securities. Your student loans were $23,000 and you had no significant credit card debt. What happened to the remaining $1.8 million? Rachel's attorney intervened. Mr. Kim, my client has provided complete financial disclosure as required by law. If you have concerns about the accuracy of her statements, you should present evidence to support those concerns. I intend to. That evening, I began doing what I do best, following the money trail. I started with the account where Rachel's inheritance had initially been deposited. Using my professional access to financial tracking databases, I traced the movement of funds from that account over the 6 months since the inheritance arrived. What I found was a sophisticated asset concealment scheme that had been carefully planned and executed. 3 days after receiving her inheritance, Rachel had transferred $1.6 million to a new account at a private bank that specialized in offshore service. From there, the money had been moved through a series of intermediate accounts before landing in what appeared to be a Cayman Islands investment fund. But that was just the beginning. The offshore transfers revealed that Rachel had been planning our divorce for at least 8 months before she'd even mentioned being unhappy in our marriage. The Cayman Islands fund was registered to a company called Pacific Asset Management, which was owned by another company called Sterling Holdings, which was ultimately controlled by a trust established in Rachel's name. This wasn't amateur hour asset hiding. This was a professional wealth concealment structure that had probably cost Rachel $50,000 in legal and consulting fees to establish. More disturbing was the timeline. The initial steps to create this offshore structure had begun 10 months earlier, when Rachel had supposedly been working with me to plan our financial future together. I traced Rachel's communications with the offshore service providers. Using my investigative contacts, I was able to confirm that Rachel had been working with a firm called Global Privacy Solutions, which specialized in helping wealthy individuals hide assets from divorce proceedings. The paper trail showed that Rachel had been planning to divorce me and conceal her inheritance from the beginning. The entire offshore scheme had been designed specifically to ensure I wouldn't receive any portion of the $1.8 million in community property division. But Rachel had made several critical errors that would ultimately expose her entire scheme. First, she'd used her real social security number when establishing some of the intermediate accounts, creating an audit trail that connected her directly to the offshore fund. Second, she'd made the transfers using our home computer and internet connection, leaving digital footprints that I could trace. Most importantly, she'd underestimated the investigative tools available to someone with my professional background and industry connection. I spent 2 weeks building a complete forensic analysis of Rachel's asset concealment activities. The evidence I compiled included bank records showing the initial $1.6 million transfer, corporate registration documents for the offshore entities, communications between Rachel and Global Private Solutions, digital evidence from our home computer showing the timing of transfers, documentation proving the funds were community property subject to division. Armed with this evidence, I requested a court hearing to address Rachel's incomplete financial disclosure. Your Honor, my attorney presented the case. Mr. Kim has discovered evidence that his wife has concealed approximately $2.3 million in marital assets through an offshore trust structure. Rachel's attorney objected immediately. Your Honor, these are unsubstantiated allegations. My client has provided complete and accurate financial disclosure. Actually, I said, I have forensic evidence documenting every aspect of the asset concealment scheme. I presented the court with a 47-page report detailing Rachel's offshore activities, including account numbers, transfer dates, and the corporate structure she'd used to hide the money. The judge reviewed the evidence with obvious concern. Ms. Kim, did you establish offshore accounts containing marital assets? Rachel's face was pale. Your Honor, I received investment advice that suggested offshore diversification for tax purposes. Ms. Kim, did you disclose these offshore investments in your financial statement to this court? I didn't think they were relevant because they weren't easily accessible. Ms. Kim, you are under oath. Do you currently control approximately $2.3 million in offshore accounts? Rachel looked at her attorney, who could only advise her to tell the truth. Yes, Your Honor. The courtroom was silent for a moment. Ms. Kim, you have committed perjury in this court by filing false financial disclosure. You have also violated court orders requiring complete asset disclosure. I am ordering you to immediately repatriate all offshore funds and provide complete documentation of your asset concealment activity. Your Honor, Rachel's attorney tried to intervene. My client was following legal investment advice. Counselor, your client established a complex offshore trust structure, specifically designed to hide assets from divorce proceedings, then lied under oath about the existence of those assets. This is not investment planning. This is fraud. The judge imposed several immediate sanctions. All offshore accounts were frozen pending complete forensic accounting. Rachel was required to pay all costs associated with asset recovery. Rachel faced potential criminal charges for perjury, asset concealment. The court awarded me 75% of all recovered assets as sanctions for Rachel's misconduct. But the most satisfying moment came when Rachel's offshore advisors abandoned her. Global Privacy Solutions immediately distanced themselves from Rachel's case. When they learned about the court proceedings, offshore service providers don't want to be associated with clients who get caught hiding assets in divorce proceedings. It's bad for business. The Cayman Islands trustee froze Rachel's accounts and began cooperating with U.S. court orders to avoid regulatory problems with American authorities. Within 3 months, Rachel's sophisticated asset protection scheme had completely collapsed. Richard, Rachel called me after the final court hearing. I want you to know that I never intended for things to get this complicated. Rachel, you spent $50,000 creating an offshore trust structure, specifically to hide money from our divorce. This wasn't a complication. This was the plan. I was scared that you'd take half of my inheritance. Rachel, I'm a financial investigator. I understand inheritance law. Your grandmother's money would have been separate property if you'd kept it separate, but you commingled it with marital assets and then tried to hide it offshore. I didn't understand the legal implications. You understood them well enough to hire offshore specialists and create a complex trust structure. You just didn't understand that lying to a forensic investigator was going to expose everything. The final asset recovery took 8 months. Of the original $2.3 million Rachel had hidden offshore, I recovered $2.1 million after legal fees and penalties. Under the court's sanctions order, I received 1. Rachel also faced significant additional costs: legal fees for the offshore scheme, penalties for early termination of the trust structure, and sanctions imposed by the court for her perjury. In total, Rachel's attempt to hide her inheritance cost her approximately. Today, I use Rachel's case as a teaching example in my professional training seminars for attorneys and investigators. Her case demonstrates several important principles about asset concealment. Offshore structures are not invisible to experienced investigators. Digital financial transactions leave permanent audit trails. Lying under oath about hidden assets carries severe legal consequences. The cost of asset concealment often exceeds the assets being protected. Rachel's fatal error wasn't trying to protect her inheritance, it was choosing deception over legal asset protection strategies, and then lying about it to someone with the professional skills to expose the entire scheme. Sometimes, the best revenge against financial deception isn't retaliation. It's simply being better at investigation than the other person is at concealment. Rachel thought she was dealing with her soon-to-be ex-husband who might hire a competent attorney. She didn't realize she was attempting to deceive a financial forensics expert who specialized in exactly the kind of scheme she was trying to execute. The $2.3 million she tried to hide offshore ended up being redistributed in my favor, along with sanctions that taught her an expensive lesson about the cost of lying under oath. Sometimes justice isn't about revenge, it's about expertise applied to hold people accountable for their deceptive choices.